Hi everybody, Jack Milligan with you again from the Plaintiffs MSA and Lien Solution, and this is your first video of 2019, so Happy New Year. Hopefully not too late to say that still. Hope it's going to be a great year for all of you. Hey, in just a few days we are going to have another national holiday, not really on the calendar, but it's become that. It's the Super Bowl. And someone asked me if I was going to be watching the Super Bowl, and I said, well, you know, I've lost interest in professional football. I've kind of lost interest in a lot of professional sports, basketball and football. Still watch a little bit of baseball, but mostly during the playoffs. But what has really impressed me in a negative way again about professional football is all of these controversies here about the referees and blown calls. The controversy in the New Orleans Saints game and how upset those fans are that the game was stolen from them. And I understand that the Kansas City fans feel the same way. Both teams, I guess, have a pretty good argument that they really should be the ones in the Super Bowl instead of the two teams that are going there. And I remember from a few years ago when I was watching one of the Super Bowls, there was a hugely controversial call at the last play that occurred in the end zone when it was quite evident that pass interference had been committed. And when they confronted the referee after the game, he said, well, we didn't want to end the game on a penalty, which of course makes you think, well, then if that's the case, then on every last play of every one of these games, I guess the whistles are not going to be blown by any of the refs, and therefore, no holds barred, do whatever you want. But that's part of the reason why I'm just not real interested in professional sports, because it seems like the rules don't matter anymore. The rules just don't matter. Holding and pass interference can be called in every play in the pros, and if the refs did call them on every play, it wouldn't take long and those two activities would disappear. But I guess the rules don't matter. Now, how is that like Medicare? Well, unfortunately, in Medicare, the rules do matter. And you can't just stick your head in the sand like an ostrich and ignore this issue. And that's because while MSAs are not required by law, that doesn't change the rule that's been in effect since 1980. And that rule says Medicare is precluded from paying for services related to your client's injuries, the conditions and injuries that they suffered in the incident or the accident that you've obtained a settlement for. Medicare is precluded from paying for those once they've discovered that your client has had a settlement. And as we've talked about before, there are several ways for Medicare to find that out. Number one, if your client's got a Medicare card in their hand at the time of settlement, the defendants are legally required to go ahead and report the settlement to Medicare. Medicare is going to have the information. But what happens if your client doesn't have a Medicare card and the defendants don't report the settlement? Well, if your client is vested in the Social Security system, they're going to get their card someday. And let me tell you, we already have seen evidence in years past of Medicare's efforts and CMS efforts to create a self-reporting mechanism for your clients, your plaintiffs, that later become Medicare eligible, which means Medicare card in hand. And what happens there is they get a letter. And the letter asks the client, your client, have they been treating or have they ever treated for injuries that were the fault of someone else? If so, if you answer yes, the questionnaire takes you to page 2, and that's where your client then is asked to fill in all the blanks as to what happened, who's the insurance company that paid your claim, what's your attorney's name and address, and give us a detail on your injuries. So the point is, look, if you're focused on this MSA issue, that's the wrong way to look at this. The right way is to say, what's the law? And the law says Medicare is precluded from paying when they discover. So how do you fix this? Well, that's the good part. We're operating in an age still where there are very, very few rules or laws regarding how to handle these obligations with regard to Medicare secondary payer. But it gives us the ability to help you and your client in many cases, most of the cases we work on, to avoid this, to avoid it with, well, one of three ways that I've talked about in previous videos and have produced digital handouts. And if you want that, call us. We'll send it to you. But it's quite possible that we can help your client avoid this Medicare issue and an MSA using the techniques that we have available to us right now. So there's no need to stick your head in the sand and think that this is just going to go away, because the risk is if you don't do anything, years down the road, Medicare can start denying payment to your client for treatments related to the injuries in your settlement. And if your client doesn't have the money to pay, they're going to call you and they're going to ask you what happened. And if you don't pick up the phone, they'll probably call another attorney. And you know what that means. That means potential complaint or a claim for malpractice. Don't be that attorney. Deal with this head on now. Don't put your head in the sand. It's quite possible if you take it on head on, we can help your client avoid it. And if we can't help them avoid it, we are bound and determined to help them minimize it to the absolute rock bottom dollar that is reasonable and defensible. Give us a call if we can help you. It's been Jack Milligan for the Plaintiffs MSA and Lien Solution. Talk to you again soon.